Welcome back. This is part 2 of the civil litigation slide series. So in this particular slideshow, we're going to cover the second part of civil litigation. We're getting close to trial now. We're going to look at the pretrial conference, trial procedures, appellate review, res judicata, and enforcement of judgments. Pretrial conference, what is it? Well, this is used to identify any uncontested issues. Sometimes parties will do what's called a stipulation of facts. It's like, okay, we all agree that this happened, this happened, this happened, and this happened. The problem that we have and the thing that we need the jury to determine is what happened here, fact number J, or whatever. They want to simplify the contested issues. They want to identify any witnesses and exhibits for trial, and they set case deadlines for motions, discovery, and related matters. So the pretrial conference is pretty important. Some people refer to it as the scheduling conference. Trial procedure. Well, federal civil trial process is governed by the Federal Rules of Civil Procedure and the Federal Rules of Evidence. So those are the two rule books that you are going to be consulting as you move forward with trial. Now, trial by jury. This is interesting. Not all trials are by jury. Some are a bench trial, which is just a judge. But a trial by jury, the Seventh Amendment guarantees the right to a trial by jury in all cases at common law in which the amount in controversy exceeds $20. Well, that applies to federal courts, but state courts have not necessarily adopted that. So in some states' courts, you do have to request a trial by jury. Voir dire. This is the process where you're selecting jurors, and it means to see or to speak. And literally, that's where the attorneys have an opportunity to see and to speak to the potential jurors so that they can select which jurors will be sitting on the case. Now, they can challenge these jurors if they don't like them, or if they've done something that it's for cause. Like, for example, if you have somebody that declares that they're, if your defendant is a minority and you have a juror, a potential juror who says, I hate all people of that minority and I cannot be unbiased. Well, that person's going to be challenged for cause. You have an unlimited amount of getting rid of those types of people. Peremptory challenges, you only have 3. And this is, you don't really have to have a reason. It can't be based on something unconstitutional like race or gender or something like that. But these are just people who you feel like aren't going to be necessarily favorable to your cause. And that's limited to 3. Okay, how does the trial go? What's the sequence of the trial? Well, it starts off with your opening statements. And again, statement is a statement. It's not an argument. A statement is where the facts are presented to the jury or to the judge in a bench trial, and simply the facts are stated. Plaintiff's case in chief, you start with that. The plaintiff is going to do direct examination. The defendant is going to cross. There's going to be some redirect and perhaps recross examination. And when the plaintiff's case in chief is over, whenever they've submitted all of their evidence and they've presented all of their witnesses, it's invariably you're going to have motions by the defendant. At this point, before the defendant does their case in chief, they are going to ask for a motion for judgment as a matter of law, saying, look, Your Honor, looking at all of this, you've got to find in our favor, or a motion on partial findings. Look, it's the same concept, same idea. Defendant is then going to present their case in chief because very rarely are these motions by the defense granted after the plaintiff presents their case in chief. They're going to go through the direct, the cross, the redirect, the recross, and then there's going to be some rebuttal by the plaintiff if necessary. At which time we will see more motions, and there's generally going to be a motion for judgment as a matter of law. Either side can have that argument. Probably going to be denied, but those motions need to be there to preserve the record for appeal. Then you're going to have your closing arguments. You notice these are arguments. This is where the attorneys actually, say, okay, jury, okay, judge, you've heard all of the evidence, and here's the conclusions that you should be drawing from that evidence. Those are closing arguments. Then the judge is going to give the jury instructions, which have been presented to the judge. So the lawyers have proposed jury instructions, what they should sound like, how they should be read. And then the judge will he selects those and agrees which jury instructions he's going to give, and that's read at that time. Then there's going to be a verdict at some point. You're either going to be liable. This is a civil case, right? You're either going to be liable or not liable. Sometimes there's a hung jury, which means, look, we just can't come to any kind of an agreement. After the verdict, there's more motions. Again, you're going to have this motion for judgment as a matter of law. You're going to have a motion for a new trial that's going to be asked for by the party who did not win. And a motion for order nunc pro tunc, which is basically a motion notwithstanding the verdict of the jury. Hey, the jury didn't know what they were doing. Then you have appellate review. Okay, I don't like what happened to me. I lost at the trial court level. What do I do? Well, I can appeal to a higher court, at which point the higher court is going to review what happened to me at the trial court level, and they're going to look for some kind of error that prejudiced me in some way. If they can find that, then they can overturn the decision of the lower court. So how does appellate procedure work? Well, when upon the close of the trial, after the verdict, and any orders, you're going to have a notice of appeal. Generally, that's done, and it should be done within 10 days of the end of the trial. Then appellate briefs are filed. Each side, the appellant files their brief. It is then responded to by the appellee. And then sometimes there's reply briefs to those. Those are filed. Those are submitted to the higher court. Then there's oral argument. That doesn't have to happen, but it generally does. And then the court renders a decision and opinion. So that's how it goes if your appeal is accepted. Not all appeals are accepted by the higher courts. Sometimes those appeals are, the writ to have those appeals heard is denied. But if it is heard, that's the order it goes in. There's something called a stay pending an appeal, which means the judgment that was entered at the trial court isn't enforced while the appeal is pending. So if somebody was ordered to go to jail or ordered to pay money or something like that, then that's not going to happen while there's an appeal pending. Scope of appellate review. The appellate court can review the lower court's decision de novo, which means of the new, like it's a completely new case. De novo on the record, which is completely new, but just looking at the record, or just on the record. The disposition, how can they decide? What are their decisions, the appellate court? They can either affirm the decision of the lower court, they can reverse the decision of the lower court, or they can reverse and remand. Reverse and remand is I'm reversing your decision, lower court, and I'm remanding it, meaning I'm sending it back to you with instructions how to do it right this time. So that's pretty much it for appellate procedure. Some terms that you need to be aware of. Res judicata. This means the thing has been adjudged. This is the idea that, look, you get to litigate this thing one time. Do not come back in here over and over and over again. You same parties, you same issues, you same claims. We're not going to hear it. That the idea, the concept of res judicata prevents that from happening. Okay, so let's say we've got a judgment. Now, how do we enforce it? Well, a judgment is an order or a declaration by a court that one party owes money to another party. Okay, so I ran over grandma, I lost. Now I owe her $50,000. Well, I do not have $50,000. Well, now they want to enforce this judgment against me because I haven't paid it yet. So the execution of judgments can be in the form of levy, garnishment, and foreclosure and sale. Basically, they can come after my stuff. Garnishment, they can garnish my wages. I'm sure you've heard of that, which means part of my paycheck is going to go directly to grandma. They can foreclose upon my house. They can sell my stuff. This is how you can enforce judgments against people who owe money. And also it ruins your credit, which is outside of the enforcement. It's just an aside. So hopefully you don't have any judgments ordered against you. Well, that's all I have for today's lecture. Again, I've enjoyed speaking with you. As always, if you have any questions, don't ever be afraid to get in contact with me. Have a great day.